In this video, we'll consider everything that happens between the serving of notice to the hearing. So let's first take a look at the complaint, which is the way notice is served. The notice to the party who's the subject of the adjudication has to, of course, state when the hearing is going to take place and where it's going to take place. Of course, this is just fundamental fairness to know when and where your hearing is going to take place. Furthermore, the notice has to state the legal basis. In other words, what is the law or regulation that you are accused of having violated, and the facts. Why do we think that you have violated that? And the notice has to provide adequate time and information to prepare a defense. So you may recall that when we talked about notice in rulemaking, we said that the notice had to be sufficiently specific, and that it had to provide a reasonable amount of time to respond, and those same requirements are also true of a complaint in adjudication. So one question, though, that arises is who can be involved in an adjudication? Because adjudications in one respect are very narrow, because there's one institution or one person who's been accused of having violated the law. So an adjudication involves a very specific and small group of people or institutions. And yet, when an agency rules on an adjudication, they establish a principle that they use in the future. And so this principle is forward-looking, and it will affect many more people in the future. So the question then is, shouldn't other people be able to be involved in the adjudication? But of course you can't allow everybody to be involved, because it's kind of like a trial and things would become a circus and it would become unwieldy. Well, there is a procedure where agencies can permit interested parties to intervene in an adjudication. So if there's a party out there who feels that they have something unique to bring to bear on the case, they can petition the agency to be included as an intervening party. The agency can review, can accept or deny that motion, but if they do deny it, then that is subject to review in the courts. But they do have an opportunity to allow other parties who are not actually accused of wrongdoing to be involved in the adjudication. So one fundamental concept that the courts and agencies deal with is the fact of standing. Now, before somebody can go to court, they have to have what is known as standing, and that means they must have suffered or be about to suffer an injury. This is because the courts do not want to be involved in hypothetical disputes. They don't have the time to decide things that aren't actually happening, and the courts actually rely on real facts, not hypothetical facts, to make their decisions. They want to make their decisions fit with reality and not a hypothetical version of reality. So if an individual has not actually suffered an injury, or if they're not about to immediately suffer an injury, typically they're not allowed to bring a lawsuit. And of course, not only must they suffer an injury, but that injury must be directly traceable to whatever governmental action that they are alleging. So for example, one way this plays out in court is that taxpayer lawsuits are usually forbidden. A lot of people are angry. They are angry that their taxes are going to support things that they don't agree with. So let's say you've got somebody who disagrees with abortion rights, and they do not want to see their tax money going to support, say, Planned Parenthood. The courts have said that taxpayers do not have a sufficiently large injury to be able to bring a lawsuit. They have no standing, and so they can't abstractly oppose laws that they oppose. Now, one very interesting case in which this played out was the United Church of Christ v. FCC, which was decided by the D.C. Circuit Court of Appeals in 1966. And this case involved an application to renew a radio license. There was a radio station, it wanted to renew its license, And so the agency was going to hold a hearing, and representatives of the public sought to intervene. So this was just a group of listeners in the local community. And the question was whether they should be allowed, whether they had sufficient standing to be able to participate. Their motion was denied because traditionally they were only granted, litigants were only granted the ability to intervene if they had alleged economic injury, or in the case of radio renewals, if they were alleging some sort of electrical interference. So, although their motion was denied, they took it to court, and this came to the D.C. Circuit, and the D.C. Circuit overturned that denial, saying that even though it was a large group of people, that in this case, the radio audience was a valuable party. They had important information to bring to bear in this decision, and that those listeners could identify programming deficiencies that might be relevant to the FCC's decision on whether to renew their license or not. Your book contains another very interesting case, again about radio licensing, called Ashbacher v. Radio Corp v. FCC from 1946, and as usual, I urge you to read it, understand it, and if you have any questions, let me know. So, after notice has been served, of course, then the process of discovery begins. Discovery is based upon the principle that each side has the right to know the evidence that's possessed by the other. When you watch trials on TV, oftentimes at the very end there's a dramatic witness that nobody expected who steps forward and changes everything. Well, that almost never happens in real life because the law has a very elaborate process to make sure that each side reveals its evidence to the other side. Now that's interesting. Why is that? If we're looking at an adversarial legal system, the element of surprise is often one way one gains an advantage over their adversary. But we don't allow that because there are many benefits, significant benefits to the process of discovery. First of all, discovery simply promotes substantive due process. As we've mentioned, our courts are more interested in procedural due process, but that's because they want to achieve substantive due process. And having all of the facts on the table certainly helps everybody arrive at a decision that will be substantively correct. In addition, nobody wants to go through an adjudication if they don't have to. Adjudications like trials take time and resources, and so having discovery can really promote settlements. One side may think that they've got a really strong case, but then when they see the evidence that the other side has, they may realize that perhaps their case isn't as strong as they thought it was, and therefore discovery promotes the ability and the desirability of litigants to settle their case before it actually gets to adjudication. And then, of course, if it ever does go to adjudication, discovery makes things much more efficient. Everybody already knows who the most relevant witnesses are, what the most relevant evidence is, and so oftentimes the irrelevant and unimportant information can be abandoned and the adjudication can focus on those issues that are significant. Your book talks about different methods of discovery. I'm not going to go into that here, so I will leave that to your reading. After discovery has occurred, the parties then come together with the administrative law judge for a pretrial hearing, and the purpose of this pretrial hearing is simply, once again, to settle. It's one last opportunity to try to have the agency and the party to come to some sort of compromise or agreement before they go to the full formal hearing. At this hearing, issues are clarified, rulings are made. The administrative law judge may rule out certain kinds of evidence, may rule out certain witnesses, may allow or deny certain defenses and certain legal arguments. All of this is very similar to what happens in a real trial in a real court. Of course, settlement is encouraged, and settlement can occur at any time. Oftentimes, an adjudication will start, and then they'll settle after that. even after the adjudication, the hearing has begun, the settlement can still occur. But assuming that the two sides do not settle, eventually the hearing occurs. And a formal hearing is, again, very similar to what you would see in a courtroom, except for the fact, of course, that there is no jury. The parties have the right to have an attorney present, and of course they'd probably be foolish not to. As we've mentioned, they have the opportunity to cross-examine witnesses, and of course any evidence that they may present. The side that is the subject of the hearing, they have the opportunity to present their own evidence. So it's not just the government who can present evidence, but the complainant can also provide their own evidence. And one interesting thing about agency adjudications is they're different in the kind of evidence that can be admitted at trial. In regular courtroom trials, as you probably know, there are strict limits on the type of evidence that can be admitted. Just to give you a couple of examples, you probably heard that hearsay evidence is not admitted in regular trials. That is, somebody can only give evidence of things that they personally know. They can't give evidence about things that somebody else told them that the other person saw. In addition, another kind of evidence that's often limited and omitted from regular trials is evidence of earlier offenses. If somebody is accused of, say for example, rape, then the jury might be not allowed to know about an earlier offense they might have had for public indecency or something like that. So why is that? If we want to get at the truth, why is it that sometimes we admit evidence that might reveal the truth? Well, the theory is, of course, that because in regular trials it's not judges, it's juries who are deciding what actually happened. They're the deciders of fact, and juries can be easily swayed by irrelevant or prejudicial evidence. If, for example, the jury hears a tape of a witness saying the N-word many times, they may just hate that witness rather than and decide the case based on that hate rather than on the facts. So the presumption is that juries who do not have great experience with the judicial system might be easily swayed. And the presumption is that in an administrative law trial, administrative law judges will not be so swayed. They are professionals, they've undergone professional training, they've decided cases of this type before, and so they will be in a better position to sift through the evidence. And so the rules of admissibility are wider in adjudications than in regular trials. So this point is illustrated in a couple of cases contained in your book. One of those is Richardson v. Perales from 1971, and the second is INS v. Lopez Mendoza from 1984, and as usual I encourage your close attention to those cases.